Welcome to This Explainer. Okay, today we are unpacking something truly fascinating. It's a brilliantly disguised experiential learning framework known simply as the theory. Look, if you've ever tried to teach teenagers anything, you know it's an uphill battle, right? So on the surface, this whole thing looks like a grueling, fast-paced legal simulation designed specifically for high school seniors. But underneath, it's a literal pedagogical Trojan horse. It's actually designed to teach cognitive psychology and decision-making under uncertainty, and the wildest part is, the students don't even realize it until the very end. Okay, let's dive into this. Here is our roadmap for peeling back the layers of this framework. First, the Westview Civil Rights Project. Second, the 13-day cascade. Third, navigating doctrinal uncertainty. Fourth, the stakeholder dilemma. Fifth, the trial theory memo. And finally, number 6, the Day 13 reveal. Let's kick things off with Section 1, the Westview Civil Rights Project. So, picture this. You walk into your senior year classroom, but you're not handed a syllabus. You're handed a massive case file. Suddenly, you aren't a student anymore. You are a junior attorney at a civil rights firm. Boom. You are plunged right into the action. You're immediately greeted by your lead counsel, Adisa Talbot, with a serious reality check. 3 weeks before trial, class is certified, discovery is closed. You've just entered McAllister versus Westview Unified School District, which is a constitutional challenge to a school district's discipline policy. Honestly, it feels exactly like a high-stakes legal thriller. And the legal stakes here? They are incredibly high. The entire documentary spine of this case relies on data from a Dr. Inés Calderón. Her 4-year impact analysis reveals a pretty stark reality for the district. Black students, who make up 17.3% of the enrollment, are receiving 41.8% of the suspensions. Now, as a student attorney, you have to use this highly technical data to build your case. And in doing so, you learn the harsh real-world difference between what data suggests and what it actually proves in a court of law. Which brings us to Section 2, the 13-day cascade. You might be wondering, how does a teacher actually run this massive legal engine over just 13 50-minute class blocks? Well, to manage the sheer volume of this field-authentic case file, these 4 student teams divide into very specific roles. You've got the lead reading attorney, who carries the core depositions, the evidence attorney, handling all that discipline data we just talked about, the doctrinal attorney, who audits prior legal cases, and the deliverables attorney, coordinating the final trial memo. Now, every student still reads every core piece of evidence, but their specific role dictates exactly how they lead their team's discussions. The whole timeline is just meticulously engineered. It flows from day 0 setup to making early path commitments on day 5, framing commitments on day 9, drafting the absolutely crucial trial memo on day 12, and finally, the reveal on day 13. But here's the truly brilliant part. Hiding inside this exact timeline, beneath all the dense legal jargon and the thrill of courtroom prep, is a massive secret curriculum. We're going to get to that shortly, I promise. Let's move on to Section 3, Navigating Doctrinal Uncertainty. This simulation forces students to take calculated risks while the documentary record is still heavily contested. I mean, nothing is handed to them. The school superintendent deflects their questions, and the prior legal cases they audit, total mixed bag of outcomes. So to prevent teams from just nodding along with the loudest voice in the room, the simulation enforces a really strict rule called caucus discipline. Step 1 is an independent right. Literally every single student has to commit to a legal theory in writing before they are even allowed to speak to their team. Step 2 is the actual caucus, where they debate those written commitments. And Step 3 is synthesis. This is absolutely crucial because it actively prevents groupthink and forces genuine intellectual commitment before any social pressure can take over. Okay, Section 4, the stakeholder dilemma. This right here is the absolute heart of the simulation. It's where abstract legal architecture collides violently with real-world human consequences. It introduces the concept of URSA. That stands for Ethical Reasoning and Stakeholder Awareness. Put simply, it's the rigorous discipline of accounting for the human beings that the legal doctrine doesn't explicitly name. Through this framework, students learn a really incredible lesson. The boring choice wins. Actually making methodical, record-based decisions that protect real people, that always outperforms making flashy, dramatic TV lawyer moves. The tension of this dilemma completely peaks on day 8. The students have to contrast the exhausted, named lead plaintiff, Charisse, who legally represents 11 families on the roster, with someone named Sharonda. Sharonda is a parent representing 200 affected families who explicitly declined to be named in the suit, just to protect their kids from public backlash. Now, Sharonda's interview produces absolutely zero new legal evidence, but it produces profound consequence. It's this light bulb moment where students realize their legal strategy has massive, unpriced consequences for people who aren't even listed in their lawsuit. All right, Section 5, the trial theory memo. On day 12, under immense deadline pressure, the 4-attorney team has to converge all their theories into one unified trial memo. So the crucial point is how this memo is actually structured. They must explicitly articulate the strongest objection from stakeholders, like Sharonda from the previous day, and they have to leave a falsification condition right there on the page, meaning they literally have to write down exactly what specific evidence, if found, would prove their own working theory wrong. It's just a complete masterclass in intellectual humility.
And finally, Section 6, the Day 13 reveal. So, we've reached the pretrial conference. The students have filed their memos, and suddenly the simulation drops its disguise entirely. The teacher stands up and reveals how what the students thought was purely legal practice was actually an elaborate trap to teach them cognitive psychology. Now, what's really interesting about this slide is how, throughout the 2 weeks, the teacher used very specific legal phrases. When students stubbornly clung to their initial idea on day 1, the teacher called it the working theory. Well, on day 13, they learned that was actually the cognitive bias of anchoring. When they only pulled deposition quotes that supported their case, the teacher called it the deposition that fits, but that was actually confirmation bias. And judging prior legal cases only by who won instead of the actual legal reasoning, the prior cases becomes outcome bias.
And this brilliantly illustrates the rest of the secret curriculum. The team's read, which is where they soften their personal views just to agree with the group caucus, is revealed as self-serving bias. The room's frame maps directly to the framing effect. And that temptation at the very end to say they knew how it would all play out, the obvious theory, is unmasked as hindsight bias. They got completely tricked into learning. I mean, by disguising abstract psychology as a high-stakes legal game, the students don't just memorize a boring textbook list of cognitive biases, they actively catch themselves committing them in real time. It's genius.
These students walk away profoundly more ethically aware. But honestly, this simulation holds an ultimate lesson for all of us in our daily lives. When your own theory is committed, the paperwork is filed, and your decisions are finally made, who does your doctrine leave behind?